Okay, this, and I don't know what it is. It's like something in the water. Sometimes um, lightning strikes multiple times, and it just absolutely amazes me. This scenario, I actually have two cases currently that are very, very similar. Um, this is the most egregious, though. The other ones were just, one was just stupid childhood behavior with threats of alternative school, but no IEP. And then the other one was, mouthing off or having an exchange on the bus, that resulted in a disciplinary homebound. But in this situation, this takes a case. This takes a cake. Because we got suicidal ideation, and we're going to punish you for it as a cry for help. Isn't that amazing? But we're not going to recognize your disability. We're not going to recognize your need, and screw you. Okay, so let's go ahead and talk about the law first. All right. Now, there's a child find component to this, as you've figured out, because the parent has requested an IEP, was denied. Now, what I need to know is whether they even denied having a referral meeting where they just decided that we're not going to go any further, or did they actually complete the evaluation process and then determine based upon those evaluations that he didn't qualify for an IEP? Because there is a difference between the two. Every school is required to have a referral meeting. All right, that is the first step in special education consideration. But that referral meeting, that is not optional. They must convene the referral meeting. Now, within the referral meeting, the school doesn't necessarily have to take the next step to get your consent if they don't believe that there's sufficient evidence to support the need to get your consent to move forward with the evaluation process. Now, I've seen many schools do that. I think it's dumb, because that still would be considered a child find violation if they were wrong and the child did in fact have a qualifying disability and was in need of specialized instruction. So sometimes it's just better to go ahead and get consent, to sit there and check that box and just double check to make sure that you guys, were wrong. I mean, because most of the people sitting in these eligibility committees, they have their particular professional hat and their expertise, and then, in other areas they don't. So they shouldn't be making broad determinations or absolute determinations like they do sometimes. Okay, but as far as the 504, he has to be failing to have a 504. That is absolutely not true. Total myth. All right. No, you just have to have a qualifying disability that impacts a major life function. And you think about what that is, a very broad term. Thinking is a major life function. Breathing is a major life function. So actually the Bush administration prior to the Obama administration actually expanded the definitions for what is a impacting disability under 504. So it's quite broad now. So they were wrong on that. Now, with regards to the struggles that resulted in the suicidal ideation, where they suspended him for 45 days, that is the thing that's insane. Okay, it's crazy and wrong, because what does that reinforce? And it's punitive, and we're punishing him for wanting to hurt himself. Come on, guys. But yet still not recognizing the duty under the law. And so this is the final aspect that I want to get to. Under the IDEA, there are even protections for kids that are embroiled in disciplinary punitive action if the district knew, suspected, or should have known that the child may have a qualifying disability and be in need of specialized instruction. So if they meet that standard, and in this particular situation, they can't act stupid. The school absolutely knew that this kid has issues and that there was a suspicion that this kid may need the safety nets programs or the safety net offerings through a 504 or an IEP. And at that point, the child is protected as though they have an IEP already during that evaluation process. So This is your mechanism to get him off of that 45 days, get him back into the classroom, get immediate supports during the process of eligibility. All right. Now, are they going to sit there and give it to you just because you go in there and say, wow, you know, James Galini, that they're probably not, they probably don't even know that aspect of the law exists, because it's not that frequently triggered, because schools aren't that dumb. This one is. So that means somebody like me would more than likely need to come in and assist you in getting that ironed out and asserting that right on the outset. I mean, you could do it, and if you private message me, or if you respond when I send you the message that I approve the post, then I can walk you through where that is. And I think you're in Alabama, but I would be more than happy to assist you in this situation, because it's something that needs to happen immediately, and to undo, to fix, and get him the help that he needs. But like I said, I could also just provide you where that is in the law, and you could walk through the process yourself, either way. But it is there. It is there. Okay? But like I said, the school has got to have knowledge, or they've got to suspect. You know, that's where that would trigger. You know, because it's almost like a punishment mechanism. Look, guys, you know, you can't sit there and punish a kid that you guys, you know, suspected, and you failed to go through the process to identify him. Okay? So there are protections. Great question. Thank you for asking it.